Hello everyone, this is Pete Enco, and I'm a partner here at Husch Blackwell, and with me is my colleague Tiffany Hetland, and we are excited, and that is no joke, we are excited to give today's presentation on the 340B Drug Pricing Program strategies for maximizing opportunities and managing responsibilities. Before we begin, I would like to cover a few housekeeping items. Now, at the bottom of your audience console are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit your questions via the question box. That makes pretty good sense. We'll try to answer all questions during the webcast today, but let's be honest, we're lawyers, we talk a lot. We probably won't get to everyone. But if a fuller answer is needed and we run out of time, we'll make sure that we answer those questions by email for you. And we truly, truly appreciate audience participation, and we encourage you to submit as many questions as you'd like. Now, if you have any technical difficulty, please click on that help icon. It has a question mark, and it provides information regarding common technical issues. And for those of you who want to reference it later, a copy of today's slide deck is available in that resource list icon that looks like a folder, and that's at the bottom of your screen. And for those of you who need CLE, the program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas. And we're still waiting on Wisconsin, and unfortunately we applied a little bit too late, so we didn't get any in Kansas, so we apologize for that. To report your hours in Illinois, Nebraska, Tennessee, or Texas, please click on that CLE widget at the bottom of your screen and complete the questions. And a recording of the webcast will be available tomorrow for watching and sharing. And once available, a link to the recording is going to be emailed to you along with a certificate of attendance. As I mentioned already, joining me is my colleague Tiffany Hetland, and Tiffany is also an attorney here in our healthcare group, and she has experience in a wide variety of healthcare related areas, including specialty pharmacy, managed care, insurance contracting, Medicare, Medicaid, regulatory compliance, contracting, transactional matters. I think I've gone through the list.
And my very favorite, 340B.
There we go. We can't forget that. So with those technical issues out of the way, I can wrap up a few of our administrative tasks by issuing some disclaimers. So as a reminder, the information that we offer today is for general educational purposes only and doesn't constitute legal advice. Please consult your own attorneys. Second, we're assuming a basic familiarity with the 340B drug pricing program so that we can focus our conversation on really communicating to you strategies as to how to set up your program, how to make sure it's operating optimally. And then lastly, because covered entities, and this is going to be a theme of our conversation, because covered entities are ultimately on that compliance hook, we're going to be viewing this webinar from the vantage point of the covered entities rather than that of a contract pharmacy, a manufacturer, or third-party administrator. But that said, even if you don't fall into one of those categories, we're hoping you still find the conversation useful and worthwhile, and particularly if you fall into those contract pharmacy or TPA categories. All right, let's talk a little bit about our agenda. We've got four areas that we want to cover with you this afternoon. First off, we want to begin with a discussion of the policies that drive the program and also enforcement. Second, we're going to briefly review the requirements for enrollment and continued participation, and then we're going to move into the business side of the equation and talk a little bit about ways to leverage contract pharmacy and third-party relationships and also manufacturer relationships. And then we're going to wrap up, and this may be the most kind of helpful section, or at least we're going to provide the most anecdotal or most anecdotes. We're going to wrap up our conversation by addressing program enforcement priorities, ways to get out in front of the compliance issues, and then also how to resolve problems once they occur. So that does it for me to get us started. I'm going to turn the mic over to Tiffany now, and she's going to kick us off with a 340B policy discussion. So Tiffany,
Sure.
take it away.
Thanks, Pete. So as Pete mentioned, we're assuming everyone has a bit of a basic familiarity with the 340B program, but it really bears reminding kind of how the program came to be and what it's intended to do. And so as you can see on the screen, and I'm sure as everyone knows, back in the early 90s, this was enacted, and it was identified as a way to make sure that certain eligible providers who tend to reach vulnerable patient populations, who tend to provide a lot of charity care, have a mechanism to kind of bring in more dollars in the door, achieve some savings, and to, quote, stretch their scarce resources. And so through the program and kind of how it has evolved throughout time, essentially we've got a list of 340B covered drugs that these so-called covered entities, these eligible providers, can acquire at a significantly reduced discount. And I'm sure, most people are familiar with this, but sort of, I don't know if you want to call it the carrot or the stick, but the way in which manufacturers play ball is because if they want their drug covered by Medicaid, they have to offer a 340B discount to these covered entities through a pharmaceutical pricing agreement. And so I just think it makes sense to really keep in mind that the ultimate goal of the program is to make sure that these covered entity providers are able to achieve some savings and to stretch their resources in order to provide more care to their community, to their constituents, to act within their grant purpose, et cetera. You might notice we have this little graphic here that talks about patients. It's a bit ironic because oftentimes the way that those resources are stretched and the purpose to which they're put is more general in nature. It's expanding services to the community. It's expanding charity care. It is not necessarily something that the patient at point of sale is seeing a benefit of. They're not necessarily receiving a discount. Certainly for some covered entities who are required to provide services on a sliding fee scale, that may not be the case. But it's just important to keep in mind that there are a lot of ways in which the program may provide value and a lot of different ways in which those covered entities may use that value.
So just to clarify, do patients who are considered eligible, do they actually benefit?
In some cases, they may.
Okay.
But it's important to keep in mind, we're going to get into this when we talk a little bit more about the eligible patient definition. A 340B eligible patient is not an indigent person necessarily, an uninsured or underinsured person. It's simply a person who has been seen and received care and been prescribed a drug at a covered entity. So again, we'll get into this a little bit later, but for example, you or I could be an eligible patient, and I think the firm provides us with pretty good insurance. So, but we can talk more about that.
That's a helpful clarification. Thanks for doing that. And then, so let me jump back into the conversation here and chat with you briefly about the second item on our agenda, and that is requirements for enrollment and continued participation in the 340B program. So first things first, let's walk through this list of providers eligible to participate in the 340B program, focusing on the acronyms. Obviously, you can read this list, but for those of you who may not be familiar with all those acronyms, we've got critical access hospitals, we've got disproportionate share hospitals, federally qualified health centers, hemophilia treatment centers, Ryan White clinics, and for those of you who aren't all that familiar with Ryan White clinics, those are clinics that have been designated by the government to provide primary care, support services, medications to uninsured, underinsured persons with HIV. And then also we've got Title X clinics. And those Title X clinics offer family planning, counseling, and other preventative healthcare services. Now, this may seem like a little bit of a pedestrian exercise, but we judge it important to work through this list because we have to stress that each facility must be registered appropriately in connection with the terms of their applicable grant. If we fail to do that, then we run into compliance issues. And again, as Tiffany's mentioned, I think I probably mentioned already as well, come the end of our conversation with you this afternoon, we're going to talk a little bit about how those compliance issues arise, unfold, and are resolved. And, just to mention that we have seen, and give you a specific example of a type of problem that might occur here, we have seen situations arise wherein a multi-facility system has inaccurately registered its locations, only to find out later, maybe, that those particular sites weren't covered by that particular grant. And again, that calls into question the eligibility of each patient who may have received 340B product from that particular site. Tiffany, you know what? Can I ask you a question here? We went through this list, and at the bottom of this list, there's this reference to certain other providers, and frankly, I forgot what we were going to mention there. Can you refresh my recollection?
Sure. So some Native Hawaiian clinics, some Indian health facilities will also qualify. And to your point, it's really important to keep in mind what kind of the possible eligible provider designations are, because as you alluded to, some may have potentially dual qualifications. They may, qualify as both an STD clinic and a Title X clinic, but the patient base may not overlap. And I would add, we are not sponsored by Apexis, which is the prime vendor for the 340B program, but they have tremendous resources available on their website, and they will actually provide, policies and general compliance guidance specific to these different providers. Each provider type will have, obviously be required to comply with the basic 340B tenets, but there will be little nuances for some of them that are really important to keep in mind, particularly, as you said, those that are subject to a grant.
Tiffany just mentioned the Apexis website, and we don't have it linked here, but if anybody doesn't have access to that or is unfamiliar with that particular website, please feel free to drop us a question, and then we'll just push that out to you so that you can readily access all that wonderful information. And again, there's been no paid endorsement. Anyway, well, Tiffany, thanks for those clarifications on the list of eligible providers. Do you want to also walk us through the covered entity enrollment process?
Sure. So I'm sure, probably most of our audience participates in the 340B program in some fashion, so they're familiar with what's, usually colloquially called the 340B database. That is the OPAIS, the Office of Pharmacy Affairs Information System. It is online, and any person, whether they are within the 340B program or not, can actually go into it. They can search by manufacturer, by contract pharmacy, or by covered entity. But basically, in order to become eligible to purchase drugs at a 340B discount, a would-be covered entity needs to go into OPAIS during a registration period and register themselves. It's a pretty straightforward process, but a couple of, traps to look out for. The first one is that registration takes place only in the first 15 days of each calendar quarter. So that would be the first 15 days of January, April, July, and October. And so, you have to make sure that you're registering during those times. And once registered during one of those periods, if all is okay, you get the thumbs up from HRSA after potentially some follow-up if they need, then you'll become eligible to start purchasing as of the first day of the next calendar quarter. So, for example, if you get registered on January 7th, all goes well, you can begin purchasing on April 1st. And so that's really something to keep in mind, because sometimes participants in the program will fall into the trap of thinking, we're all good, off to the races, I can start purchasing. So you'll want to keep that in mind from a planning perspective. The other thing to keep in mind is that while the rule of thumb is that most registrations are going to occur during that quarterly process, there are a couple of instances where there might be exceptions that are granted by HRSA, either on a covered entity-specific basis or perhaps on a geographic basis. So, for example, sometimes if there has been a devastating flood or a hurricane or some kind of an act of God like that during a registration period that affects a portion of the country, HRSA may decide to extend the window just for covered entities who would have been affected by that and colorably couldn't have registered during that period. Additionally, covered entities may obtain a HRSA exception on, again, a specific covered entity basis. A lot of times things driving that are acquisitions or mergers or some kind of a change of ownership where a very large safety net provider's ability to continuously participate in the program might be in jeopardy because of that change of ownership, and HRSA wants to make sure that they are still able to participate, realize the benefits, and continue to serve their community. And so, again, that's an exception-based process, and an application has to be made to HRSA.
Can I ask a question here? So you talked a little bit about this initial registration, these initial time frames. So what happens after the initial registration? How often are you re-registering or recertifying?
Sure. So there's an annual recertification process that covered entities have to undertake, and so it's not really a one-and-done thing. And the purpose of that is to make sure that they continue to meet the requirements. It's kind of a double check. It also is, I would imagine, important to manufacturers to make sure that there's slightly more of a vetting and registration process than just, Scouts Honor. We still meet the definition. So yes, covered entities have to do that initial registration and then that recertification process.
Quick turnaround time. And then another question related to this: have you encountered any hiccups in this process? It seems pretty straightforward.
It is. A couple of instances in which I have seen the most hiccups relate to, number one, contract pharmacies, and then number two, to grant programs.
Okay.
And so we'll talk a little more about contract pharmacy covered entity relationships later, but it's important to keep in mind that any contract pharmacy relationship also has to be registered and is also subject to those same quarterly periods. And so if you have a signed contract pharmacy agreement during the registration period, great. You can, make sure you get it signed first, you can register, but then you're still going to have that lag period. If you contract with a pharmacy for services outside of the cycle, that's fine. Go ahead, you can sign your agreement, but it's got to be kind of put on ice, if you will, until a registration period. The other thing I mentioned where, you'll see a hiccup now and then is with grant programs. Okay. So there's kind of an added level of complexity there, and you want to make sure that you as a covered entity are in touch with, your state official or whoever kind of your point of contact is for your grant, because you need to ensure that you are registering as an entity type that is consistent with the scope of your grant letter. And so it's important to maintain those documents and to make sure that there is good and clear communication between you and, again, whoever's administering your grant, because I have seen instances where the grant officer perhaps is a little bit loose and says, yeah, sure, that looks like an STD clinic, and come to find out later during a HRSA audit, well, really it ought to have been Title 10 or more limited. So that's another kind of registration hiccup. You just want to make sure you have that good communication and clarity with whoever the grant officer is.
Yeah, and to amplify and somewhat restate what you just said, we have encountered situations that we've had to untangle, wherein, say, an FQHC has that particular grant in place, but they've also got a Title 10 grant, they got the STD grant that you mentioned, but those grants may pertain to particular facilities within the whole of the FQHC system, and unless they're tracking who's receiving services where and whether a patient is eligible, we've run into situations of diversion where drugs have been dispensed to folks who should not have been eligible to receive those 340B projects. So anyway.
Exactly. No, and at least one of those instances was, in fact, bad communication with the grant officer. So we'll bring that full circle. And yes.
Okay, super. Well, that's about it for covered entities. Let's move on, and we've referenced this already, but can we talk a little bit about eligible patients now?
Sure. So the patient definition itself is pretty basic, and it makes sense if you kind of look at each of the points here. The first being, obviously, there has to be some kind of a bona fide relationship between the covered entity and the patient. The covered entity has to maintain the patient's care records, and they have to maintain kind of responsibility for their care. The idea there is we don't want an opportunity to game the system where a covered entity is just sort of filtering patients through the door in hopes of realizing some 340B savings off of them. We want to see that that's actually someone who's served by the covered entity. The second prong has to do with the actual prescriber within the covered entity. And so that prescriber either has to be employed by the covered entity or providing services to the covered entity pursuant to a contractual or another similar arrangement. That's another one where, we're trying to avoid having the system gamed by just, if a prescriber happens to sneeze in the area of the covered entity, we're going to take credit for that prescription. And so that's kind of prong two. And then the third one, and this really goes back to what we were just speaking about, is whatever services they're receiving have to be consistent with that covered entity's either their federal grant or their program designation. And so to your point, sometimes there's some conflation where there might be multiple designations, but we wouldn't expect a Title X clinic, for example, to be administering clotting factor or trying to, realize 340B savings on ordering that. And so those three prongs are pretty basic. I think what we're going to get into over the next couple of slides, and then potentially talking through some compliance stuff at the end, is that once you start looking at this in practice, there can really be some traps that you can fall into, and there are a lot of legitimate but different ways to interpret this on a covered entity by covered entity basis.
Perfect. So, Tiffany, you walked us through the definition of eligible patients. Now let's talk a little bit about problems that arise with patients. And from our perspective, we've talked about this at length, they really fall into two buckets. And that first bucket is that generally, and there's a reason why we use generally, and we're going to talk about that in a moment, generally an individual is not considered an eligible patient if the only healthcare service, this goes back to that relationship point you just made, if the only healthcare service he or she receives from the covered entity is the dispensing of a drug. So that's that first bucket. Second bucket relates to Medicaid patients, and covered entities have to determine up front whether they're going to use their 340B purchased drugs for their Medicaid patients, that would be a carve-in, or whether they're going to purchase their drugs for their Medicaid patients from other mechanisms. That's the carve-out. So let's talk a little bit about that first bullet point. The reason why we've used that word generally there is that there are a few categories of covered entities from that list that we just looked at which are allowed to consider or to treat an individual to whom they dispense a drug as an eligible patient, even though all that they're doing is simply dispensing the drug to that particular individual. So that kind of moves away from that relationship nexus that you're talking about. One of the best examples of that type of covered entity is Orion White Clinic. And then now with respect to that second bullet point, what we're referring to there is that duplicate discount prohibition under the 340B program. In some quarters, it's also referred to as double dipping. And to refresh any recollections that may need refreshing, Medicaid programs do receive rebates from manufacturers for certain drugs that are dispensed to beneficiaries. And in order to avoid situations in which a manufacturer may get hit twice, both with the Medicaid discount and then, or the rebate, and then also the 340B discount, there is this requirement that the 340B programs either opt to carve in, include the Medicaid patients in their program, or carve out, exclude the Medicaid patients from their program. And if they do opt for that latter approach, it is critical that the program is managed in such a way. And
Pete, I think you mean the former approach. You're talking about carving in. I think that requires a little extra care. Yep.
Yes, because dispensing drugs to that particular population can create significant compliance concerns. Thanks for that clarification. Was there anything else you wanted to add on this?
Yeah, just a couple of quick points. So on this first bullet, as Pete mentioned, it's typically your state-operated or funded kind of drug programs that might fall into that very narrow exception. And the idea there is, for example, individuals who are HIV positive, there's a countervailing public policy to that general rule where we want to make sure that those folks are medication adherent and that kind of those limited programs that are serving them have the resources they need in order to furnish that and to avail themselves of the 340B discount. I would caution that that's something, if you think that you qualify for that narrow exception, I would talk to your in-house or outside counsel about it. Make sure that in fact you do, and that you are complying with all of the requirements there. That's going to require some careful record keeping and documentation to make sure that you're handling that in the appropriate way. With regard to that second bulletin about the Medicaid, I don't want to say this to suggest that carve-in is not appropriate, but usually it's safest to assume that you're going to carve out, because that one of those basic tenets Pete mentioned of the program is no duplicate discount / double dipping. In order to carve in, you have to coordinate between the covered entity, a contract pharmacy, if any, the state Medicaid program, and by the way, each state Medicaid program handles Medicaid and 340B differently, how they handle their exclusion files, what they allow and disallow, any reporting requirements if it's managed Medicaid. And then you also have to notify HRSA. So there's a lot of hurdles to clear there, not to say that you can't do it or shouldn't do it, but that's another one where I would point you to your in-house counsel or outside counsel to make sure it's structured appropriately. So
before we move on, I got to ask you this. When we were prepping for this section, you took issue with the image on this particular. Do you want to mention why?
It gave me a chuckle because I want to make sure that we are very clear with everyone that the 340B program covers outpatient drugs, not inpatient drugs. And so hopefully this person is just, under a quick observation and is not a hospital inpatient, lest we mislead the audience here. So.
Thank you.
Sure.
All right. Let's move right along. So we've got about 5 questions here that I think also illustrate some of the problems that we encounter with respect to the definition of eligible patient. Tiffany, do you want to pick just a couple of these and give us some answers to them?
Yeah, so I think this first question around whether being an eligible patient ties to your ability to pay harkens back to a brief comment I made earlier. So an eligible patient is simply someone who meets the 3 criteria that we talked about just now. It does not have to do with needs. Now, it is true that several of these covered entity types are likely to have patient populations that are largely, underinsured or uninsured or otherwise may have some difficulty paying. But, for example, as I mentioned, I would actually hazard to guess that I am a 340B eligible patient because my primary care doctor is at a large hospital system here in town that I know is a dish. And so when I go and I have a prescription written and I take it to my favorite is my local CVS, and that's not a plug for CVS, just a nice gentleman who works there. But when I take it there, I would venture to guess CVS probably has a contract pharmacy relationship with that hospital. And so in that case, I would technically be, for purposes of that prescription, an eligible patient. And I certainly, I can afford to pay for my prescription and I'm fortunate to have good health insurance. So it's important to keep that in mind, that when we're looking at is someone an eligible patient, nothing to do with ability to pay. And that makes sense because, we want the question to be, is the covered entity, serving people? How can we leverage that service into realizing savings that can then be directed to those patients who are needy and perhaps can't pay? So that's kind of the first one. And for time considerations, I don't want to go through all 5, and we'll probably sideways get into these with some of the compliance questions. But this middle one I think is interesting. How many refills is the eligible patient permitted? The answer is there's not really an answer there.
Oh, interesting.
Different covered entities will put different parameters around their eligible patient definition. And so some may say, I'm not comfortable that we're going to continue to meet that first relationship prong for any longer than 6 months. Others may say, so long as this is a trailing refill from an initial eligible prescription, we're comfortable with it, even if that may translate to something like a year's worth of refills. So that's always kind of an interesting question, and it really goes to policies and procedures and making sure that you're sensibly implementing the definition.
So this last question on this list here, that one's actually very interesting to me.
Yeah.
Because, we're in a metropolitan area. There are a lot of covered entities around us. What happens if one patient is receiving services from a variety of covered entities? Are they an eligible patient at all?
No.
those purposes?
No, but they could be.
Oh,
the answer
okay.
is maybe.
Okay.
But it's a really interesting question. As you pointed out, this is something that comes up frequently in dense metropolitan areas. Now, I think Kansas City is a great city. We really see this a lot in New York. There's a lot of hospitals in close proximity to each other, and as a result, there are a lot of prescribers who may have contractual arrangements with multiple hospitals. And so typically, if you're talking about kind of and we'll get into this, but a virtual inventory model,
okay.
There's a retroactive 340B eligibility determination occurring, and a lot of times the pharmacy is querying its paid claims data based on a list of prescriber NPIs that the covered entity has furnished, saying all of these people have contractual arrangements with us or employed by us, they might write a 340B script. And so that same individual may appear on multiple covered entities' NPI lists, and as such, the same prescription can be flagged as, oh, this was a prescription. This claim pertains to a prescription written by this particular NPI, and as a result, is sent to every one of those covered entities who have that NPI on their list for eligibility consideration. And at that point, they kind of have to butt it up against their own encounter data and make a determination. You hope at the end of the day that that results in only one of them saying, aha, this is an eligible prescription. But in some cases, going back to this refill question, it's possible that the patient was, getting a refill, but there happened to be a new encounter around the same time with a different covered entity, and perhaps they think that that's a match. So it gets a little bit tricky, but at the end of the day, I think an important takeaway is that eligible patient is a prescription-by-prescription determination, not a person-by-person determination. So just because a prescription of mine has been 340B eligible, and for purposes of that prescription, I'm a 340B eligible patient, doesn't mean I get a little badge that I get to wear for the rest of my life that says I'm a 340B eligible patient.
You are not a card-carrying member.
No, unfortunately not.
Okay. Well, thanks for running through those questions. Let's talk a little bit about leveraging relationships. I think the con is back to me now. So let me quickly run through the economics of how the program works. And then, Tiffany, I'm going to ask you to amplify what I mentioned here. Anyway, the math is very, very, very basic. And it basically goes like this. If you're able to purchase a drug at a lower cost and still bill and get paid the same amount for that drug, you're going to make money. Your spread's going to be larger. And now, hearkening back to the policy review that we articulated at the beginning of the webinar, that's all well and good, as it allows the covered entities to stretch those limited resources that you were talking about, Tiffany, and that in turn allows them to serve more patients, probably serve them better. But it does become a problem when those monies that are realized through the program, which were supposed to be used for the benefit of that uninsured, underinsured, vulnerable population, they aren't used in that way. And we've all heard stories, and unfortunately Congress has heard stories as well, about those few covered entities that are arguably taking things maybe a bit too far and generating what may be viewed as excessive revenue from participation in this particular program. And to that end, and as noted on this slide, what looks to be like the third bullet point there, there's increasing pressure to impose certain accounting requirements, certain documentation requirements on covered entities to make sure that they can demonstrate that they're using those savings appropriately in a manner that the program was intended. So that's that. Do you have any other comments on what's up there?
I do. Yeah, if I could just make a couple of clarifications. One thing that I think we both want to be clear about is that there is not a cap on how many savings you can realize.
Right.
That's okay. There's just scrutiny as a result of how much the program has grown. There also is not a good and finite definition of what's an appropriate use of those savings. I think, though, there's a good gut check for what's not an appropriate use. And
so what would that be?
Well, I mean, like buying, perhaps a private plane that's only for the use of, management or something like that. Something very egregious. But that kind of goes to Pete's point about documenting the use of program savings, because there are a lot of ways in which indirectly the savings may be furthering the grant purpose or furthering whatever, the dish hospitals, community programs, or whatever. And so that's why even if there is not an explicit requirement to document, we always advise our clients to document. We advise them to have a policy, however general, saying 340B savings will be used to further, in some general description. And even if you can't get a dollar for dollar accounting, we recommend having some kind of an effort to be, documenting the programs that, are benefiting from those dollars, or how they're being used. And we think that that is preventative in terms of if this becomes a requirement, or if, a particular covered entity or group of covered entities is subject to, congressional scrutiny or something, they can look at that. But it also kind of helps from a planning perspective to make sure that, you're thinking about how your program's implemented and making sure that, it's being handled in a manner that's consistent with the original purpose.
Got it. So we're supposed to be talking about, and we have, realizing cost savings here. But I think the folks listening in are probably aware of this, and if they're not, we can help them. But you can have situations in which a particular dispense maybe doesn't realize any cost savings. And I think this is that winners-only conversation we were having previously.
It is. I mean, so it's one thing to, have a prescription that was for a 340B covered drug. It was an eligible patient encounter. Great. In theory, that's good. That does not have to be a 340B eligible prescription. You can further filter out losers, or, as we call it, a winners-only model. You can make sure that only profitable claims to the covered entity are included, and that's very consistent with the spirit of the program. An example of a way in which a claim could ultimately prove to be a dud for a covered entity would be if after the covered entity has procured the drug at the discounted price, looked at what the delta is between that and the replenishment price they're going to receive, then netted out, for example, the contract pharmacies dispensing fee, perhaps the 340B administrators administrative claims fee, or whatever fee they're charging for kind of their services. If that ends up being a loser, they can go ahead and set that to the side. You don't have to choose to purchase the drug at 340B pricing. You can just, again, disregard it, and we do view that as perfectly fine and appropriate. You're making sure that you're protecting your savings.
Excellent. All right. Let's move on to pharmacy relationships. I think I'm going to take this particular slide. So as you're aware, excuse me, just because an entity is covered by the program doesn't mean that it has the ability to dispense drugs to the eligible patients. So if it can, great. If it can't, well, unfortunately, HRSA has accounted for that kind of situation, and it allows the covered entities to enter into contract pharmacy relationships. And what's interesting is the number of contract pharmacy relationships a covered entity can enter into is virtually unlimited. Now, the only kicker, actually there are two kickers here, but the only kicker is that each of those contract pharmacy relationships have to be recorded on the OPA database. So that's pretty straightforward. The other kicker is that each contract pharmacy relationship must have a written agreement in place which contains all the HRSA required elements. And if you're interested in those elements, if you want a refresher in those elements, they were published in the Federal Register back in March of 2010, and they're listed out there. But what's interesting, if you actually read through all those required elements, they really distill down to maybe 3 or so particular requirements, and that is who owns the drugs, how are the drugs being tracked, what type of tracking systems are in place at the contract pharmacy level, and then what procedures are in place to ensure that we don't have a situation in which we encounter drug diversion. Again, drug diversion not in the DEA sense of the word, but in the 340B program sense of the word. We've given a drug to an ineligible patient that was purchased under the 340B program. So that last point, when we talk about drug diversion, really is tied to inventory management. And Tiffany, do you want to maybe elaborate a bit on,
Sure.
virtual versus actual inventory models?
I sure can. And one, I think, clarification we want to make is that you can certainly have an in-house pharmacy and contract pharmacies. That is perfectly fine. It doesn't have to be one or the other. And we'll get into this with the compliance discussion, but you can have as many contract pharmacy relationships as you want, but, and this ties a little bit to this inventory, the covered entity is always going to have the compliance responsibility. And so you don't want to have more than you can responsibly manage and audit and maintain oversight of. So yeah, talking about program inventory, when the 340B program first came about, it was sort of assumed that drugs were going to be dispensed out of covered entities' in-house pharmacies. Pretty quickly it was realized, well, that's not going to work always. And so covered entities were allowed to have very limited contract pharmacy relationships. At that point, given how limited things were and how new the program was, a physical inventory model was common. And this is still done today with some covered entities, and there's absolutely nothing wrong with it. But basically what happens is you are prospectively, the covered entity, purchasing 340B discounted product and putting it on a special designated shelf or in a special designated closet or what have you. And so when a prescription comes in that has been prospectively labeled 340B eligible, you pluck the 340B eligible drug off of that special 340B shelf. As you can imagine, once we get into the territory of having a lot of contract pharmacy relationships where that's a huge cash outlay at the outset, and where contract pharmacies are not really interested in having a special shelf or storage facility for each covered entity, that kind of brought about this virtual inventory model. And so the notion there is that usually through some kind of a software solution, dispenses are being tracked and determined eligible on a retroactive basis. And so the pharmacy is just dispensing drugs in the ordinary course, and on some recurring basis it is querying its paid claims data for drugs that, or for claims that correspond to a prescription written by someone on the covered entity's NPI list. They'll then send those for examination by the covered entity or its designee, and then upon its determination that it's eligible, the covered entity will order at the 340B discounted price a replenishment product that the contract pharmacy then just receives into its regular inventory. And so these accumulators are all maintained virtually or through the software solution, and the pharmacy is able to maintain this sort of neutral inventory and not have to slice and dice between covered entities' pre-purchase 340B drug.
Thank you. All right, so that's the first relationship we wanted to talk about that needs to be leveraged. Let's talk about the second, manufacturers. Tiffany, I think you're up.
Sure. So, I mean, I think everybody's very familiar with the basics of this, the ceiling price and so forth. The manufacturer is not able to charge a covered entity more than that maximum amount or that ceiling price for a 340B covered drug, assuming that there is an appropriate agreement in place. The covered entity has to have, opened up an appropriate purchase account. They have to have completed all of the formalities. Interestingly, we kind of mentioned Apexis earlier as the prime vendor. Apexis kind of wears two hats. The first is, so they're the prime vendor that has been contracted by HRSA to administer a program where covered entities can sort of aggregate their purchasing power and obtain potentially sub-ceiling price discounts and actually save even a little bit more. The other thing that Apexis does is it's basically kind of the call center, the helpline, and an alternative resource center to HRSA for all things related to 340B. So they maintain some FAQs. They have a very helpful chat service if you have questions. So worth giving them a look. But at the end of the day, yeah, you have those manufacturer relationships. Most frequently, covered entities are going to be leveraging a wholesaler, though. It's the manufacturer who's obligated to provide the discount if they want their drug covered by Medicaid, but typically there's going to be a wholesaler that's administering some kind of a chargeback and making sure that the 340B pricing is what's offered to the covered entity.
Got it. All right, let's move on to the third relationship. Tiffany, you're still on.
All right. So I mentioned very briefly earlier that, some covered entities may use a 340B administrator. This is very common, and essentially they are entities that frequently will have a proprietary software program that will allow them to assist the covered entity in determining eligibility of claims and in maintaining these accumulators. So as you can imagine, upon finding out that a prescription is eligible, that doesn't necessarily trigger an immediate order for a replenishment product. You may not have reached a unit of issuance. You can't necessarily buy one bottle of pills from the wholesaler, for example. And so these 340B administrators are really playing a very key role and being subcontracted compliance obligations that are those of the covered entities. And namely, again, that is making eligibility determinations, and then as a corollary to that, appropriately maintaining accumulators and managing some of those ordering functions. And so we always encourage our clients to make sure that they have very tight relationships and very good agreements with those administrators, because typically the administrators, rightfully so, will have a suggested template, but it's really important for the covered entity to have good communication and to understand what's contained in that template, because it's certainly possible to customize it, and it's recommended to customize it, because at the end of the day, the covered entity has the compliance responsibility, and they're going to have their own interpretation of the eligible patient definition and so forth. And critically, they are going to have the relationship with the contract pharmacy. And so the third-party administrator may sort of sit in the middle of the contract pharmacy and covered entity, but they may not have a direct relationship with that contract pharmacy. So that's kind of harkens to the need for the covered entity to have a good relationship there.
Yeah, and if I can amplify that second bullet point there, the reason why we're so hung up on this idea of agreements having clear expectations is we've encountered quite a few situations where those clear expectations just weren't established.
They were vague expectations at best, yeah.
That handshake that we have there, yeah, we'll get to it, right? But we've run into situations where, each party may have looked to the other to establish the appropriate pharmacy.
Right, they're each pointing at each other,
right. Yep. Wasn't that your responsibility for looking at that? No, I thought it was yours, right?
Yep.
A related circumstance is when we run into situations where each party's looking to each other for information as to how to register a child site or how to register a contract pharmacy. So in that former situation, we can tell you about a situation in which the fees, the dispense fees, the pharmacy dispense fees ended up being off by a factor of 10. And Tiffany, guess who was responsible for that?
Well, I'm going to guess it's usually the covered entity.
You are so right.
So one takeaway from today.
In that latter circumstance, we found out that child sites weren't registered under the appropriate grant. And again, who bears that burden?
Well, it's the responsibility of the covered entity, but I'm guessing we had to.
We had something to do with that.
Yes.
That's exactly right. We had to unpack that situation and resolve it on behalf of the covered entity. But all that said, although we're joking a little bit here, this really is a two-way street with the agreements, because the covered entity, as we said time and time again, and we will continue to say, is ultimately responsible for compliance with the 340B program requirements. But in addition to that, the TPA wants these agreements to be precise as well, so they are not in a situation in which the covered entity is pointing to them saying, you were supposed to do that. In that latter example that we were talking about, where the covered entity registrations were off, unfortunately the third-party administrator had to basically make the covered entity whole for lost revenue, lost cost savings that occurred during the period of time that the program was shut down to investigate and resolve the problem. So again, it's a two-way street there.
And I think we would caution, we were not involved on the front end of that one.
You're right.
We would have cautioned against kind of the over-reliance upon the 340B administrator there. They're very competent, most of them, but there are certain functions that the covered entity needs to make sure that it's having a good line of sight in.
So we've got a few minutes left to talk a little bit about compliance issues. First and foremost on that list is audits. And as we said multiple times now, ultimately the compliance buck does stop with the covered entity. I can't stress that enough. But as a corollary to that, HRSA does have the right to come in and audit a covered entity for compliance purposes. And to add further pane of scrutiny, manufacturers can come in and audit covered entities as well. Now, once a compliance issue is discovered, usually what that means is diversion. And I think we've mentioned what diversion is, but just to reiterate, diversion is a situation in which a 340B product is dispensed to an ineligible patient. So essentially, the 340B covered entity is realizing a cost savings that it should not have otherwise realized. When that happens, often what as we mentioned on this particular slide here, when that happens, sometimes manufacturers do a refund. In worst case scenarios, if it happens kind of over and over again, it's a systemic issue with the covered entity, it can result in removal from the program. The other thing I should mention relative to audit before we move on is, if HRSA does come in and find a instance of non-compliance, and they come in again and they find the same instance of non-compliance, HRSA does have the latitude to basically label that issue or instance of non-compliance as a systemic or an egregious issue, and that can result in removal from the program. So just to be aware. Did you want to offer anything there, or should we just push on?
I think we can push on in the interest of time. Yeah.
So once we go through that audit process, a corrective action plan is usually required, and essentially the corrective action plan, as it says on this particular slide, it's got to be implemented within 6 months of its approval. What's interesting here, though, is not only does that corrective action plan need to address the issue that has been identified by HRSA, it also has to go beyond that and discuss areas of improvement and how those areas of improvement are going to be addressed.
And we said that's new within the last year to 2 years. It used to be that you were addressing the findings, but I think they wanted to see a little more proactive work on the part of the covered entities to make sure that they were getting out in front of something that might become a problem down the line.
And again, repeat offenders may be subject to repeat audits, so just be aware. We've got this slide here talking about child sites and contract pharmacies. I think we've touched on that enough, and we've also touched on this concept that covered entities are ultimately responsible for compliance over the whole of their 340B program, including their child sites and contract pharmacies. So we can jump ahead to identifying compliance issues. So a few slides ago, when we were touching on the HRSA and manufacturer audit issue, we said that covered entities, and I'm quoting this here, covered entities must ensure program integrity and maintain accurate records documenting compliance with all program requirements. Now, when a covered entity on its own discovers an instance of noncompliance with program requirements, well, a number of processes are triggered. So as you're likely aware, because if nothing else, we've flagged it already with you all, most instances of noncompliance are going to boil down to situations in which a covered entity, either through its on-site or contract pharmacy, dispenses a 340B product to an ineligible patient. That's that diversion issue that we're talking about. This can be a one-off event. Maybe the patient receives a 340B drug when the patient didn't receive health care services from the covered entity. And the covered entity wasn't a Ryan White clinic. So it can be a one-off, or it can be a systemic issue. The definition of eligible patient at a particular covered entity may just be completely off. And this whole population of individuals is pulled into the program and are dispensed 340B product when they shouldn't. So in either instance, those types of situations need to be reported to HRSA and possibly, not necessarily, but possibly to the manufacturer. We're going to talk about that next. Did you want to amplify?
I do. I just want to say one thing here, Pete, and this should not scare people off of going in and proactively identifying issues. You don't want to roll the dice that you're not going to get audited by HRSA. We absolutely recommend that you undertake regular self-audits of both yourself and of your contract pharmacy relationships. And so that's actually a factor that I think HRSA looks at and looks on favorably, frankly, if they see that there's a history of the organization trying to ferret out its own issues.
And again, you can read what's on the slide here. If we do get into a situation where we have identified noncompliance, the notification to HRSA has to go out and contain those elements. And again, to put in another plug for Apexis, the notification or sample notification form is on that Apexis website.
And I think we want to be clear that there is an analysis. The moment you see that you have a potential issue is not the moment that you self-disclose it.
Yes.
So, and I think that's what Pete's going to get into here.
That's perfect a transition into this next slide. Reporting compliance issues. And just like most regulatory compliance issues, not every problem needs to be reported. And in the case of the 340B program, manufacturers don't need to be alerted of every instance of noncompliance. What tips the scale when it comes to reporting a situation, I'm using air quotes here, to a manufacturer is whether the diversion was material.
Or whatever the issue is. Usually it's some flavor of diversion, but whatever, it could be double dipping.
Exactly. But it's usually diversion. And unfortunately, there aren't any hard and fast rules that are going to guide us when we're making those materiality determinations. And although I should note already that Apexis has some extremely helpful materials on its website, it's really the covered entity's decision as to what it should report and what it doesn't need to report. At the end of the day, the decision's likely going to come down to money. And what's interesting here, just as a bit of a sidebar, from an enforcement standpoint, the 340B program is essentially left to the covered entities and the manufacturers. And to some extent, what HRSA is telling them is, you guys got a problem, you work it out. So when something goes awry in which the drugs are purchased, you guys work it out. You, the covered entity, you, the manufacturer, work it out.
And we should point out that is largely a function of the fact that the government is not kicking money into the 340B program. These are not government-funded discounts. This is a mandatory discount that the manufacturer is furnishing. HRSA has certainly stepped up kind of its auditing and enforcement activity around imposing, like restrictions on covered entities and stuff. But to Pete's point, the reason the manufacturers have a direct audit right and the reason why the biggest concern is always, have you made the manufacturer whole, is because those are the manufacturer's dollars that are funding the program.
Exactly. So, and I mentioned it all comes down to money. And for covered entities with larger 340B programs, that materiality threshold is often tied to, say, a percentage of the 340B drug purchases from manufacturer, either a dollar percentage or just a volume percentage. And then for smaller programs, which may not generate a whole lot of 340B business for any particular manufacturer, sometimes just a simple dollar threshold will do in terms of determining whether we've got a material an issue of material noncompliance. And
while this is a nuanced decision, we do recommend as a compliance point that covered entities have some kind of a standard, some kind of a set out policy or statement of how they're going to make materiality determinations. And again, not to put another plug for Apexis, but they have establishing a material breach threshold document, for example, on their website. But it's a nuanced decision. You probably should talk to in-house or outside counsel about it, but definitely make sure there's some kind of a guiding document that's maintained internally.
And to kind of take that point and run with it a bit further, we have encountered situations where covered entities haven't had that definition of materiality up front, and only when they're in the throes of investigating a compliance issue are they deciding, is this material or not. That's never a good approach to take. We want to make sure that up front, beforehand, before we get into any pickles from a compliance perspective, we know what a material breach is for our organization. I think that's about does it for reporting the compliance issues. We're nearly done here. Tiffany, do you want to just quickly comment on how you might get removed from the
Sure. Well, I mean, once you no longer meet the definition of covered entity, you have a potential problem. And so at that point, you could no longer be purchasing 340B drugs. You need to make a notification to HRSA. I think we can certainly, these are some examples here. Obviously, as Pete mentioned, the other, probably less of a loss of eligibility and more of a just kick the heck out of the program is if HRSA gets fed up enough with you and you've got those systemic and egregious problems, HRSA has the discretion to say you're not eligible to participate any longer.
And is that it then?
I think so. We're just going to wrap up. I mean, I hope that it has been abundantly clear throughout the program that the covered entity bears the ultimate compliance obligation. You should make sure that you have some guiding documents within your organization, policies and procedures. Make sure that those set out for you kind of the principles of your program, and especially what your 340B eligible patient definition is, flushed out from those 3 prongs we talked about. Always try to ferret out your own problems. HRSA is really looking to see that you have oversight of your own program and your contract pharmacy relationships. And then kind of to that end, make sure that you have really good, clear communication with your contract pharmacies, your third-party administrators, any other vendors, and make sure that those contracts are very detailed and clear.
The only other strategy that I'd offer up is, and this kind of stems to that first bullet point that relates to material breach, don't over-report. Because once you do report to either HRSA or, worse, the manufacturers, that unleashes a whole series of processes that you may not be able to control and that may just kind of run on forever. So really, put a lot of thought into what we report as a material breach. So with that, we are at the top of the hour. A couple of questions did come in. We'll make sure we get back to you via email with respect to those questions. The questions, among other things, deal with materiality, patient eligibility, and the like. And so to wrap up our webinar today, I just want to thank you again for joining us for the program. We're hopeful, Tiffany and I are very hopeful, that we offered helpful information to you and your organization. And if you haven't done so already, please click on that survey icon at the bottom of the screen, complete the survey, and that feedback that you give us really assists us in providing important quality programming in the future. And just as a reminder for the lawyers on the call, the program has been approved for Colorado, Illinois, Iowa, Missouri, Nebraska, Tennessee, and Texas CLE. And as I mentioned earlier, Wisconsin's still pending. And then to reiterate, a recording of the webcast is going to be available tomorrow for watching and sharing. And then once available, we'll also send you a link and a certificate of attendance. That's it, folks. Thanks so much. Have a great day.
Thank you.